The name you have on the case and who I am, it's two different people.
You want to smile about it and laugh about it? Take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. I'm not threatening you. Say one more word, and that's contempt. 30 days. 30 days.
All right, everyone. Today we're examining one of the most intense courtroom confrontations you're likely to see. The man at the center of this hearing walks in with visible confidence, but that confidence quickly shifts into repeated displays of disrespect toward the court. His constant interruptions and refusal to follow standard courtroom procedure cause the tension to escalate far more quickly than expected. At times, it almost appears as though he is deliberately testing boundaries to gauge how the judge will respond. Throughout it all, the judge maintains firm control, responding with clear legal authority and methodically dismantling each argument presented. Situations like this highlight a recurring issue: individuals convincing themselves that established laws simply do not apply to them. However, courtrooms operate on structured legal frameworks, not personal interpretations or belief systems. As the exchange unfolds, it becomes a powerful example of how that mindset often unravels under real legal scrutiny. The hearing is both dramatic and revealing. I'd like to know your thoughts on his behavior. Feel free to share your perspective. And if you appreciate detailed courtroom breakdowns like this, be sure to stay tuned as we continue analyzing how this situation develops.
Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
You understand, first of all, that if you do be direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
That progressed surprisingly quickly. Once again, it demonstrates why Judge Simpson has developed a reputation for handling these types of cases with direct, no-nonsense authority. He does not allow distractions or unnecessary arguments to derail the proceedings, and his approach keeps the courtroom structured and controlled. What remains puzzling, however, is what individuals who follow sovereign citizen beliefs expect when entering situations like this. The man involved appears unusually relaxed, even amused, smiling and laughing as though the hearing is entertainment rather than a serious legal matter. His demeanor raises a broader question. Does he truly understand the consequences he may face, or is he intentionally disregarding them? Historically, arguments rooted in sovereign citizen ideology have consistently failed in courtrooms. That makes the continued reliance on such strategies even more difficult to understand. It invites discussion about the reasoning behind maintaining a position that repeatedly collapses under legal examination. For now, let's continue watching and see how he handles his next appearance as the situation continues to unfold.
Your name?
My name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the Motor Vehicle Code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how The name you have on the case and who I am, it's two different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding third degree?
So,
Do you understand the nature of that charge? You just need to answer my question.
for the record,
Take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days.
This individual appears determined to act against his own best interests. The 30-day contempt ruling was not sudden or arbitrary. It followed multiple opportunities for him to cooperate with the court. Judge Simpson can be seen exercising patience, offering repeated chances for him to respond appropriately and engage respectfully. Yet those opportunities are consistently dismissed. Rather than using the moment to clarify his stance or demonstrate respect for the process, he continues making choices that further complicate his situation. It raises the question of whether he fully understands the seriousness of courtroom expectations, or whether he is intentionally refusing to comply. Watching this unfold underscores the importance of basic courtroom conduct and clear communication, especially when personal liberty is at stake. The outcome feels particularly frustrating because it appears largely avoidable. I'm interested in hearing your perspective on what his objective might be. Share your thoughts as we continue to his third appearance and see how he approaches the situation next.
Recalls the case, people of the state of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding third degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
you understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you.
Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right, if you would either turn that over to the court officer so that they can provide that to Mr. Severin so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said,
So first of all, watch your
You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a Sess QV trust matter involved in this? Or is my social security number attached to this at all? Go figure.
Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th.
To be honest, part of me expected Judge Simpson to increase the penalty after those final remarks. Continuing to challenge the court after receiving a clear warning is an extremely risky decision. There's a limit to the patience any courtroom can extend during a single hearing, and this individual seemed intent on testing that boundary repeatedly. While his confidence was undeniable, he entered the courtroom relying on unsupported legal claims and refused to reconsider his position, even after it became clear that his arguments were not being accepted. This situation serves as a reminder of how critical proper courtroom behavior truly is. Judges possess the authority to issue contempt rulings specifically to preserve order and respect for the legal process. Attempting to challenge authority through disrespect or misinformation rarely strengthens a case, and often leads to harsher consequences. The moment also highlights the distinction between genuinely understanding one's legal rights and relying on inaccurate interpretations that hold no standing under actual law. Watching Judge Simpson maintain composure and control throughout the exchange was both tense and compelling. His calm, decisive handling of the disruption demonstrated professionalism and firm adherence to courtroom standards, ultimately keeping the proceedings on track. I'd like to hear your thoughts. Do you believe the 30-day sentence was appropriate, or should the consequences have been more severe? Share your perspective. And if you enjoy in-depth courtroom analysis like this, stay connected for more breakdowns and discussions.